And a very good morning to Madam Mela. My name is Muhammad James Rishad bin James Sembungan, and I am from group number 7. And for today, my group and I will be presenting about mistake, which is one of the causes that can create avoidable contract in the law of contract. And in this presentation, we'll be talking about the definition itself, the types of mistake, law cases related to this issue, legislations, opinions and suggestions, and finally conclusion. And our team consists of 6 presenters, namely me, James, Shah, Audria, Samira, Iskandar, and Hani. So without wasting any time, we will now begin our presentation. So for the first part of the presentation, which is definition of mistake, I will pass it on to the second presenter, which is Shah. Thank you.
Hi, my name is Pratiksha. I'm here to talk about definition of mistakes. In the realm of contract law, the term mistake pertains to a distinct circumstance wherein either one or both parties participating in a contractual agreement, committing an error or experiencing a misapprehension concerning a basic facet of the contract, subject matter, prohibition, stipulation, or
Muhammad James
indispensable
bin James
component.
Sempurngan, and for my part, I will be presenting one of the mistakes available in the law of contract, and that is common mistake. Now, what is common mistake, you might ask? Common mistake is a situation where it arises when both contractual parties possess a mutual misunderstanding or erroneous opinion regarding a basic element of the contract. For example, I went into a contract with one of my friends, and in the contract, it clearly stated that both parties must finish their part by this week. However, me and my friend misunderstood it and decided to finish our parts next week, and this will render the agreement void. All right, and the details of common mistake is first up, the breach must pertain to the fundamental premise upon which the contractual agreement is based, and it must be of significant importance. Now, let us go back to the first example that I gave earlier, where me and my friend misunderstood the date of submission, we would like to call it. So we know that if the contract stated that our parts must be finished by this week, it means that it cannot be delayed or it cannot be handed in earlier. It must be submitted on this date, on this day, on at this hour. So there we can see that it is of significant importance. Next up, in the event that a visual mistake is present, it might serve as a basis for the retraction of the contract, meaning to say it will render the agreement void. So for unilateral mistake, I will pass it down to my team member. Thank you.
Hi, Madam Bella. My name is Estefany, and I will be explaining the second type of mistake, which is unilateral mistake. So basically, a unilateral mistake in the context of contract refer to the situation where only one party of the contract make a mistake or has a misunderstanding regarding the legal aspect or legal consequences of the contract. There are two types of unilateral mistake, which is mistake of facts and mistake of law. So I will start first with the first type of unilateral mistake, which is mistake of fact. So basically, mistake of facts held by one party regarding a certain fact or event that is relevant to the contractual agreement. It has the potential to render the contract voidable, granting the mistaken party the choice to rescind the agreement. This significance is contingent upon the mistake being a fundamental fact that pertains directly to the essence of the contract and carries considerable consequences for the responsibility of the parties involved.
So this first one is going to
Move
be
to the
about common
next
mistake,
type of
which is the
unilateral
case of
mistake, which
Cahill
is mistake
and
of
Cadwell.
law.
So
A
this case
mistake of
involved
law
a
is
contract
not
between two
valid.
parties,
Is
Mr.
not a
Cahill and Mr.
valid
Cadwell.
defense in
In this
contract law,
contract, Cadwell
which
agreed
means, for
to
instance,
rent
a
music
party
hall
is
called
often
Red
unable
Lights
to
to
evade
Taylor
its
for a series of
contractual
concerts. However,
responsibility
before the
by
first concert
asserting
could
a
take
lack
place,
of
the music hall
comprehension
was
or
destroyed by
knowledge
fire. As a
regarding the
result,
law.
it became
This
impossible to
particularly
perform the
evident
contract
is
as
in
originally agreed
cases
upon.
where both parties involved in a
Taylor sued
contract has
Caldwell for breach of
committed
contract,
a
seeking damages for the
significant
losses he had
and
incurred in preparing for
mistakenable
the
legal
concert.
mistake
Caldwell
that
argued
directly
that he should
impacts the
not be held liable
fundamental
for breach of
aspect
contract
of the
because the
agreement.
destruction of the music
So
hall
that's
was
all from
beyond his
me
control,
for the two
and it
types
had
of
become impossible
unilateral
to perform
mistake.
the contract due
Thank
to
you.
this unforeseen event. The court ruled in favor of Caldwell, establishing the principle that if the performance of a contract becomes impossible due to circumstances beyond the control of either party, then the contract is considered frustrated and neither party is liable for damages resulting from non-performance. This legal principle came to be known as the doctrine of impossibility or frustration of purpose. This case of Taylor and Caldwell is significant in contract law because it clarified the circumstances under which a contract can be discharged due to impossibility, and it has since been cited and relied upon in numerous contract law cases. It recognizes that if an unforeseen event makes the performance of a contract impossible, it may be just and equitable to release the parties from their contractual obligations. Furthermore, the case of public prosecutor and Muhammad Nur bin Muhammad Yusuf, which is about mistake of law. In this case, the defendant, Muhammad Nur bin Muhammad Yusuf, was charged with possession of firearms and ammunition without a license, which was a violation of the Firearms Increased Penalties Act 1971. The defendant claimed that he was not aware that he needed a license to possess these items as he believed that they were gifted to him from his father. The central legal issue in this case was whether the defendant's claim of mistake of law could be a valid defense. The High Court held that mistake of law is generally not a valid defense in Malaysia. However, in this particular case, the court considered the defendant's circumstances and found that he genuinely believed he did not need a license for the firearms and ammunition. The court also considered the fact that the defendant was not a sophisticated individual and had received the items as a gift from his father. As a result, the court acquitted the defendant, accepting his defense of honest and reasonable mistake of law. Also, last but not least, it's important to note that this case is an example of a situation where the court allowed a defense based on mistake of law in exceptional circumstances. In general, mistake of law is not a recognized defense in Malaysia, but there can be exceptions depending on the specific facts and circumstances of the case. Thank you.
Hello, my name is Muhammad Skandar bin Ashwaddin, and I'm going to talk about legislation provision in contract of law. So, in Malaysia, contract law and the concept of mistake are primarily governed by the Contract Act in 1950. There are three sections that I'm going to talk about. First is Section 20, second is Section 21, and the third is Section 23. So, in Section 20, agreement void where both parties are under a mistake as to a matter of fact. Then for Section 21, effect of mistake as to law. And for Section 23, when mistake of one party as to matter of fact entitles the other to avoid the contract. That's all from me, and I'm going to pass to another person for their part. Thank you so much.
I'm Samira. I'm here to present about the opinion and suggestion. In our opinion, numerous factors lead to void contract. Nevertheless, mistake is one of the most prominent ones. In a suggestion, we suggest that legislative body in Malaysia should tighten the law to ensure less occurrence of voidable cases due to mistake.
For the conclusion, it is with high hopes that after listening to our presentation, we hope a deeper understanding of what causes a contract voidable is achieved. We hope that we can see that what type of mistakes can cause a contract to become void and etc. And not to mention, we hope that a professional approach of explaining the definition of mistake in the law of contract can be executed. Meaning to say, we hope that those who listen to our presentation can effectively present to other people on what are the types of mistakes in the law of contract. So that is all from us. Thank you for listening, and we hope to see you on our next presentation. Thank you and goodbye.